We pray. Amen. We have apologies for absent from Senator Pernell Charles Jr., Mr. Julian Robinson, Ms. Juliet Cuthberg, Mr. Robert Nestor Morgan. Okay, in terms of the minutes, unfortunately, we do not have them for this meeting. We expect that the minutes of the last meeting will be ready for when we convene next time. All right. In terms of, well, I already said welcome. So in terms of opening remarks, for today we will begin at clause 4. But I also want to alert members that there was an email document that was emailed out to everyone from the AGC, and the AGC did some research looking at the data protection legislation as it relates to deceased persons. If you will recall, in the definition of, of personal data, the definition there said that data relating to a living individual, and if I recall, it was Member Golding who queried that as to what would be the status for deceased persons. And so the AGC has taken the time to look across various jurisdictions, and they've summarized the findings. And I think I'll call on them to say, but I think in general, when I looked at it, other jurisdictions made provision for deceased persons, whether it was time, in terms of the time, or in terms of their living relatives or persons who could speak on their behalf. So I'll call on the AGC just to add to this.
Thank you, Chair. In conducting the research, we were actually quite ably assisted by the ministry as well, who found about over 30 jurisdictions as well that had similar provisions. So we're indebted to the ministry for the support they provided. So what our research has revealed is that in different jurisdictions, depending on the policy and how you intend for the data of deceased persons to be used, there are different regimes that are set out. So this document essentially takes you from what the general approach is from a GDPR perspective, and then we look at other jurisdictions that are not states party to the EU, but they do have legislation that governs the application of data protection provisions to deceased persons. So I'm proposing, if the committee and members of the committee are minded, to just look at a few of the countries that we have here, so you have a general idea of how we could perhaps incorporate it in Jamaica, subject to our own social realities. So, as I indicated, the starting point...
Sorry, Madam Chair, just a suggestion. You know, I know we have a lot of ground to cover with this bill, and a lot of good research has been done here with this. Just speaking for myself and my colleague here, we will be quite willing to just adopt the position that Trinidad has, and sort of make it a common regional position, and save some time, unless you really want to, you know, plow through what all these disparate places have done. Yeah.
I agree with you, Member. The research was just good to look across different jurisdictions, but in general, we can see that they made provision, and you know, I think the committee members are minded to make similar provisions.
Unless the ministry feels some violent objection to the model that Trinidad has adopted, which it does recognize that there is a privacy interest in the personal data of a deceased person that is worthy of some protection. You know, I would be happy for us to just move on and just make that decision, but you know, it's obviously not for me to decide.
Okay, what I'm hearing the committee say, and I'm in agreement with, is the adoption of the regime in Trinidad, if there's no dissent.
If I may, though, Chair, because there are a number of things in the Trinidad legislation. So the only one I have a little pause for is there's Section 44 that talks about the archives of Government of Trinidad and Tobago could disclose our archives. So we have an Archives Act, and we have, I guess you'd call it the government archives. They have not, though, been collecting that much information anymore and have been leaving it to departments and ministries to deal with their own older documents. I know this because we have had, from the chambers, have been having discussions with archives over the years who have said that they have also run out of space. So the thing is, we probably would need to expand what you have here in like Section 44 to ensure, because I think the intent of Section 44 is that all the older documents more than likely would have been going all the way to the archives, and so you would have been able to approach the archives for certain things.
It does say the archives of the Government of Trinidad and Tobago or the archives of a public body. So depending on how the word archive is construed, it could just mean stored material, historical material in
Right.
in
But
any
except
public.
though, so for instance with the chambers, we don't really have what we call archives, you see. So I think we would, my only point was that we would have to tweak this a little bit to make it relevant and applicable to how we have been doing things in Jamaica.
Well, point taken, and let that be done. But the broad approach is okay. Yeah.
Okay.
Chair, also just following on that, we would also have to consider how it would work in relation to Clause 38, which deals with disclosure of information for research, history, and statistical purposes, because the provision in Trinidad, Section 44, would limit what is currently in 38.
I guess this could be made subject to 38.
Member Golden is saying it could be made subject to Clause 38.
The archival provision, I mean, yeah.
You can convey to us exactly what is it, where you see the challenge between the proposed section and Section 38.
All right, so right, so Clause 38, for example, in subsection 4 allows for the data to be processed and the results of research or statistics made available as long as it's not in a form that does not identify the data subject or any of them. But if Section 44, as under Trinidad's legislation, is included, it would mean that even if the data doesn't identify the person, once it concerns information about someone who has not been deceased for 20 or more years, you still couldn't use it for or disclose it for research or statistical purposes. Yeah.
So I would suggest that this Section 38 regime be carved out as an exception. It's by making 44 subject to it, so that within the 20-year period you could use that data for statistical purposes or non-identified, in a manner for research that doesn't identify the individual. Yeah.
Okay, so the committee is in agreement that some provisions be made for persons, for data of persons who are deceased, and we will leave it up to the AGC and the technical persons to write the correct wording. All right? So we'll move on to clause 4, and the clause 4 deals with the information commissioner and the governance structure around the information commissioner. MSET? Just explain clause 4.
So good morning, everyone. Morning, Chair and members. So essentially, comments from stakeholders with respect to clause 4 primarily related to what seemed to be the autonomous nature of the Office of the Information Commissioner. There were recommendations in relation to some governance arrangement, and there were proposals from stakeholders that this governance type arrangement could be from a parliamentary oversight. So we would have looked at oversight and transparency and accountability, and we know that concerns raised regarding transparency, accountability, and oversight are noted. Given the nature, however, of the Information Commissioner and its remit, it needs to be autonomous as possible. On page 28 of the ministry's matrix, would have indicated that if the committee is minded to establish direct oversight, then consideration could be given to something in the form of a commission or a board, or a parliamentary or direct parliamentary oversight. And we would have looked at, in particular, the Integrity Commission Act as an example of something that the committee could consider. In relation to comments raised by the Broadcasting Commission and the Access to Information Act, we point out that the policy is that the Information Commissioner will ultimately be responsible for that piece of legislation as well. However, that doesn't take place immediately on the legislation coming into force, but rather what is now in the bill is that the ATI Act would have to give effect to that. And so,
saying there's a provision in the bill that deals with that, but doesn't amend the ATI Act. What does it sort of say then?
So, look at clause 4.3. The commissioner shall perform the functions conferred on the commissioner under this act, and such other functions as may be conferred on the commissioner by the Access to Information Act. So it contemplates that the Access to Information Act will be amended to give the Information Commissioner powers over that piece of legislation. What would have informed this position is the fact that, for example, if you look at what happens in the UK, the Information Commissioner is responsible for both the Data Protection Act as well as their Freedom of Information Act, rather than two separate persons treating with essentially access to public data, or data that is in, or information that is in the public domain, public sector domain, and of course the data protection legislation.
Sorry, so Chair, what role would this Information Commissioner play in relation to ATI applications? The ATI has a regime where you can seek information. There's, I believe, an officer that has to be appointed in each MD&A for addressing those issues, and then there's an appeal process, an appeal body or tribunal of some kind. So will this Information Commissioner replace the appeal tribunal, or what would the role be?
So the role would be effectively the role that is now being carried out by the ATI unit, which is responsible for public education and awareness, treating with questions that the public may have in relation to how to utilize the Act. That's primarily it. But every other thing would remain in place. So the ATI officer within ministries, departments, and agencies would continue, and the appeal tribunal we'd look at how that could work in terms of whether you need a separate appeal tribunal, because we do have within this legislation an appeal tribunal established, so that one appeal tribunal could treat with both types of appeal. So essentially, they would play that compliance role, ensuring that they being the Office of the Information Commissioner in relation to the Access to Information Act, compliance by public sector entities with the ATI Act, as well as public education awareness and so on. So that's what is contemplated, really a replacement of the ATI unit itself, which is a unit within a ministry as opposed to something that stands on its own.
Where is that unit housed now?
With the ATI?
I believe they are with the Office of the Prime Minister, if not the
one?
Ministry of Education, Youth and Information.
So it's contemplated that this role is becoming more expansive than originally contemplated, or you'd agree that the role is an expansive one, rather?
The Office of the Information Commissioner?
Yes.
Well, not expansive in the sense that what we contemplated from the beginning in terms of a policy was that they would straddle the office would straddle the two pieces of legislation and give that some oversight as well. But we've seen models where that happens, and the UK is an example of where that happens.
So as autonomous as you'd want such an office, what oversight are you recommending? I mean, because from my perspective, I mean, some oversight is required. I think I'd prefer parliamentary versus a board personally, but some oversight must be in place for such a critical role.
So you're going to a different issue there then. Okay. Yeah. My view is a little different on this. I don't really feel that Parliament provides effective oversight for the parliamentary commissions because of the stresses that Parliament is already under and the volume of work that it has and the limited resources, including number of parliamentarians, with an ever-increasing proliferation of parliamentary commissions. So I don't like the idea of one individual having powers without any effective oversight on that person. I don't think that is a good model. And so I would prefer that there be some form of oversight by a board of this commissioner, like there has been for the Integrity Commission, which is working its way. There are teething pains around that process, but ultimately those will be resolved. And it was a very deliberate decision to structure the Integrity Commission in the manner it does, where you have the persons who can investigate and prosecute, but they are accountable to not so much the prosecution in terms of prosecutorial decisions, because ultimately the DPP has control on that. But in terms of administrative matters and so on, there is a board of commissioners that provides oversight for them, and that's how the Financial Services Commission works. And there are others. So I really don't like one individual having too much power, and then you don't have any effective oversight.
We're on the same side, and I think that's what the ministry is saying in terms of looking at the Integrity Commission model. We talked about the EOJ, the Electoral Commission model as well, as an example. So yes, we agree that so much power should never ever be vested in one person.
The parliamentary commission, the parliamentary committee that is supposed to review reports, for example, hardly ever sits. So a lot of those reports, we haven't even established the Parliamentary Oversight Commission for the Integrity Commission. Even though the bylaws were amended by the Act from February last year when that came into effect. The bylaws of the House have been amended, but the Commission hasn't even been appointed. And the reports from the parliamentary commissions that come to Parliament each year, there's supposed to be a reports committee that actively reviews them and sees what issues there are in them and that just doesn't work very well because of the excesses of what is needed to run Parliament and the limited resources we have. So I think a board structure, as you have suggested, Minister, is the way to go.
If I may, I know that in the discussions from another joint select committee when they were reviewing the INDECOM Act, this discussion also came up. And we had done some research to look at models in other jurisdictions, and we did find some support for having a board. I'm going to use board in a loose sense because it's a board sort of structure, an oversight, which was not a parliamentary committee oversight. It was really a board. And we did find support for it in other jurisdictions in Africa and elsewhere as well. And again, the feelings were the same. The rationale for having that kind of structure were very similar to the concerns being expressed here.
So practically,
in fact, the report of that Joint Select Committee on INDECOM recommended the establishment as one of our many amendments to the INDECOM legislation, most of which were coming from the Commission itself. Having worked with that legislation, they wanted various things to be adjusted. Some were from other sources, but one that was approved was the idea of establishing a board, an oversight committee or board for INDECOM, but that hasn't happened yet, but it was a recommendation.
Just for practically, I understand what Member Golden is saying, and I agree with you in terms of the practicality of actually implementing the oversight. But just to note that because the Parliament is failing to handle its oversight responsibilities, the answer is not to move the responsibility away, it's to stop failing at its oversight responsibilities. So just as a point of note. But practically, I understand what Member Golden is saying.
Take your point, but just to also make the point, I don't think this Information Commissioner is a commission of Parliament, is it? No, so it is not even set up in that structure. So I think, yeah.
Question to Member Goldin. Is there a significant difference between the structure of the EOJ versus the Integrity Commission, or they're pretty similar?
There is some difference because the EOJ, because it operates in the highly politicized world of elections, the structure has been deliberately set up to ensure that the two major parties are represented there, and then there are independents who have, I think, certain things that only they can deal with, and so on. So it's a kind of a specialized model that worked there. But
so the Integrity Commission model would be the better one then?
Perhaps. I mean, or you could even look at the way something like the FSC works. You know, I mean, I think if the criteria for appointment to that board ensures independence and qualified persons are there with the necessary skill set, you could look at a simple model where the board is appointed by the minister and having consulted, you know, or something of that nature. Or if you wanted to go the Integrity Commission route, there it's quite prescriptive as to who the board should, you know, it says 2 judges, the Auditor General ex officio, somebody from civil society who's in the interested in integrity matters, I think, and one retired, very senior public servant. So it's very prescriptive as to how that board is comprised.
Okay. Yeah. So given the nature of what we're dealing with, I like that prescriptive approach to who should be on the board and what skill set and what interests they have.
Yeah. I mean, I'm not as au fait with the bill as perhaps others are. So in terms of the role that this Information Commissioner is playing, the kind of skill set you'd want to have on the board, providing oversight for that person, I wouldn't feel I'm the right person to make that suggestion, but I do like the idea of a board structure. Yeah, and given that it's not a parliamentary commission, I'm not sure why we would depart from the normal regime where there's a schedule which sets out how the board is comprised and who appoints it, and it would typically be the minister. And you might say there should be at least one person with this skill, one person with that skill, and that sort of thing. Maybe the ministry could come up with what they would recommend as the right skill set for the role that this person would be playing.
And Chairman, also I think we would want a little clarity on the functions of the board, because I think there is some concern about who would actually have the authority to undertake certain functions? Is it that, because I don't think you're saying that you're taking away that authority from the Information Commissioner. It's really just pure oversight about how to ensure that the commissioner is doing what he or she is supposed to do and do it correctly under law.
There might be HR issues, for example, within the department or whatever. Presumably the commission is going to have staff. There may be complaints, and can complaints, for example, be elevated to the level of the board if they're not satisfied as to how they've been addressed by the commissioner, that sort of thing. Yeah, but I agree not to take away the powers that the commissioner has and put those powers in the board. That's not the idea. Yeah.
Okay, so MSET, we're going to leave that with you to provide the AGC with some further clarity on the board, criteria to use for membership onto the Board of Commissioners, so on. So we're agreeing that the governance structure should look like that of either the Integrity Commission or the FSC. All right. So we'll move on to part 2, rights of data subjects and others, clause 5. And I will call on MSET to just explain clause 5.
Madam Chair, please forgive me. I have to go back to clause 4 because there is something that I still am not understanding, and perhaps the ministry can provide some clarity. I still don't see how the Information Commissioner's Office and all that pertains to it will operate with the ATI. So, for example, let me give you a case in point. In every ministry, and in the private sector, you have an ATI officer. Under this bill, it is proposed that you're going to have an information officer.
A data protection.
Yes, information data, the technical term, but essentially the same thing. I'm not understanding. It's that person will have both roles. Is that the information officer now under the ATI will also be the data officer? And how will the ATI Act work with this new act? If you could just give some clarity for me.
So essentially, the two pieces of legislation will operate separately. And whatever is now contained in the ATI Act will continue. What the OIC will do is to give effect to that and be responsible for the compliance as it relates to that legislation. So the ATI officers, for example, within a ministry or ministries.
So the personnel who now work at the ATI office, not the ministry, now the ATI office, those persons will now be answerable to the Information Commissioner?
That is what would be is contemplated. And again, as I said, this piece of legislation doesn't give effect to that. The amendments would be required in the ATI Act to give effect to that. So what would essentially happen is that within the structure of the OIC, you will have personnel that is responsible for, or that would be responsible for, liaising and treating with access to information or freedom of information type issues, alongside other officers that would be responsible for compliance as it relates to the data protection legislation itself. So it's operational and administrative, and would be oversight for both pieces of legislation in relation to how public and private sector is giving effect to or are giving effect to this data protection bill or act when it comes into force, and how public sector entities are complying with the ATI Act itself. So the interface would be with the Information Commissioner. An ATI officer existing could call the commissioner to say, assist me with this, should this be exempt, should I reveal this, for example. So it's that kind of oversight we're talking about. And so too, members of the public could go to the OIC and say, in relation to the ATI Act, please provide guidance on how I am to or how I can engage a ministry, for example, in relation to accessing documents.
So the tribunal, and I think Member Golden mentioned it, and I'm not sure what the response was, but the appeal tribunal under the ATI Act, that one goes to, what will become of that? Will that still be under the ATI, or will that be subsumed under the Information Commissioner's Office?
Well, what we would anticipate in the amendments that would be done to the ATI Act is that you would direct to one tribunal. So both pieces of legislation will direct to one tribunal, but not separate tribunals. So there isn't an ATI tribunal per se, but a tribunal that is looking at both pieces of legislation, because I think that would be the most effective and efficient and effective way to treat with that.
May I suggest, Minister, and I do understand the complexity of this new bill, but it seems to me, particularly because of what you have just said, Joaquin, that we should not be looking at this provision in particular without doing the effective amendments to the ATI Act. I believe that, ideally, it's time to revise long past to revise the ATI, but I think it may be useful for us to revise the ATI, particularly those sections which are going to be impacted by the Data Protection Act now. And I hear you with the tribunal, but unless you, for example, amend the ATI Act to give effect to the appeal tribunal coming to the Information Commissioner's Office, there'll be no standing for the Information Commissioner or for anyone to go to the Information Commissioner's Office when established to say, I need guidance, or I have applied to this Ministry for Information. They have denied me, and it is not an exempted information. So I think perhaps it may be useful to do the amendment simultaneously. It's just something I'm throwing out there for you to consider.
And the point of the member is taken. This ministry doesn't have responsibility for that piece of legislation, and so we would have just been understood. This is why you would have seen it, the way it is now in terms of the writing, but the thinking generally. So, but we take the point back. I suppose, Chair, with your colleague ministers, you can have the discussion around the Access to Information Act. The Prime Minister.
The PM. The OPM. All right.
May I ask which ministry is responsible for the ATI?
The Office of the Prime Minister.
Office of the Prime Minister.
Okay.
So, because I think that this would be a decision between your ministry and that ministry in terms of giving the thought.
All right. We take, what I should say that from the ministry's perspective, Ms. Murray, you were saying that the way this bill is laid out took into consideration the interface that would have to happen between the Office of the Information Commissioner and the Access to Information Act on that office, bearing in mind that the access to information includes other information beyond personal data that we're talking about. It's just a much broader, remit of that office. So we, under this bill right now, we're just trying to make sure it's in alignment, or it doesn't contravene, is that the right word, that act.
Minister, that until or unless the Access to Information Act is amended, then this provision here, or whatever powers that were given to the Commissioner, really would be in conflict then with the Access to Information Act and the powers there too, because the access to to the extent that, for example, the Access to Information Act states specifically the process for appeal and how that is undertaken. Until or unless that provision or those provisions are amended, the reference here under 2B to the Access to Information Act really would be, it is given, unless that provision in the Access to Information Act is amended, then this provision will be in conflict. Or if not in conflict, what you're doing, you're giving two offices the same power. And if we're giving two offices the same power, then the question is, which office do you go to?
But doesn't this say such function as may be conferred on the commissioner?
There wouldn't be any conflict, no. Effectively, what would happen is that if the ATI Act is not amended to give the Information Commissioner oversight over that piece of legislation, then what currently obtains would continue to obtain. And if there is an appeal, if there is a request under the Access to Information Act, for example, that is denied, and that complainant wants to take that matter further, then they will appeal to the appeal tribunal under the Access to Information Act. As I think the chair indicated, and as we know, the ATI Act is a wider act that looks beyond personal data. In fact, personal data is an exemption under the ATI Act. So it looks at how government, the transparency as it relates to government and documents and records that are revealed to the public on request. So it's slightly different, it's much different from this. And contemplation here is that if you have a complaint, anyone, a data subject, then that complaint will go to the tribunal that is established under this piece of legislation, or would be established under this legislation.
But you see, I don't think we're too far apart, but what I'm saying is we have to take due care to ensure that the necessary amendments that are required under the ATI are done within a timely manner to ensure that there is no conflict.
The only thing I would add to that quickly is just, we have a proliferation of appeal bodies established under legislation for a wide range of things now. And again, it's a resource issue as to how effective that is. And if we can amalgamate and have a single appeal body that would handle both sets of appeals, it might be a useful way of approaching it. I actually feel there ought to be an appeal, there ought to be a consolidated appeal entity with a wide range of persons who are on it, covering different disciplines, who can be impaneled to hear appeals under a wide range of statutes. So we have, the UK has this idea of a first-tier tribunal and so on now. They've gone far down the road with that, but I just think we have this very siloed or fragmented approach to appeal tribunals, and maybe we should consider this is outside the remit of this, but just consolidating that. But for purposes of this, at some point you may want to just consider having one appeal tribunal rather than two for appeals.
All right, point taken, member, with regards to appeals, but as you indicated, it is outside the remit of this particular session at this time, but nevertheless it's a good idea, a good practice to look at these entities that we have to see how they can be streamlined better. With regards to the Access to Information Act, again, the ministry can ensure that there is no conflict between that and this bill, but according to clause 3B, it would seem to me that it is within the remit of the Access to Information Act to confer functions on this commissioner, on the information commissioner, and not vice versa. Right? All right. All right, so subject to getting the AGC getting clarification regarding the board and any such other clarification. I think we as members agree that the structure of the Information Commissioner should be like that of the Integrity Commission or the FSC or some combination thereof.
And Chairman, I had noted a section in MOCA. So the MOCA Act established a committee, which is why I keep saying I'm using the word board loosely. But I pointed out to the ministry that they could look at the functions of that committee to help guide what they're going to do here as well. Because just quickly, so they have an oversight committee, and the objectives are to hold the Director General and other officers of the agency accountable to the public in the performance of their functions. Well, it's a little more elevated than what we're discussing here, so it involves the GG as well as consultation with Prime Minister and Leader of the Opposition, which is a little more elevated than what was being discussed. But just to give some guidance again with how the functions could be formulated.
We're in agreement. All right. Okay, so we'll move on to part two.
Just 2 points on clause 4. There was a recommendation, this is on page 29 of our matrix, development of codes. There was a recommendation that the commissioner take into account the views of trade associations in the development of mandatory codes. And we were proposing an amendment. So it's a slight amendment just to say that the commissioner will consult persons appearing to represent data controllers, because while it is that some trade associations and or other association, let me put it another way, bodies have established representatives, a PSOJ, a JCC, for example. Some may not have that kind of structure, but there may be someone that is acting on their behalf, although very loosely. For example, a National Consumer League or so on. So we were proposing an amendment that the commissioner would consult with persons appearing to represent data controllers.
Could I ask for the word on page 29 on the development of codes in the far right-hand column? But could I ask for the word appearing to be replaced with like nominated or something like that? Because appearing sounds like you're faking it.
But your recommendation on this is where? On page 29?
Page 29. Look on the development of codes in the blue, right? The blue colored.
I see, all right.
Yeah. And I'm just asking for the word appearing to be changed to something akin to nominated or tasked with or... Do we have agreement from committee members?
I think the reason they use the word appearing is because they may not be formally hold themselves out as being a representative body for this purpose, but they nevertheless have some interest and expertise in this area sufficient to make them worthy of being consulted with. So I think the word appearing was just to try and capture that idea.
Okay.
Yeah.
So anyone with interest?
Yeah.
Pretty much?
Yeah.
Okay.
I mean,
All
but
right.
given
So
your point,
noted.
maybe they can find a better verb.
Yes.
But yeah.
Right. Chair, I just wanted to bring attention to the definition of trade association, which includes any body representing data controllers, and wondering, based on the points that were raised, whether now we want to make separate provision for recognizing another set of persons other than bodies representing data controllers.
That's what Member Golden was saying. The word appearing is really loose and informal, and it would include a lot of other entities that have an interest and are not necessarily formal trade associations, right?
Yeah, so I'm not suggesting that we broaden the definition of trade association, but the question is who they should consult with in the formulation of the codes. And I think the recommendation was that rather than leaving it strictly only trade associations, there may be other persons or bodies that would be worthy of being consulted with. But it's the ministry's point. You know,
no,
so
but my point was that the definition of trade association broadened that to include any body representing data controllers. So I'm just wondering if the point was to go even wider, and who then would be contemplated outside of anybody representing data controllers.
Right, I think the member was saying anyone who has an interest, right, Mark?
Yeah, I mean, I was attempt to extrapolate from what the ministry had said, so I think they should answer the question, really.
Yeah. If the interpretation of anybody representing the data controller would mean a structured organization, for example, a Jamaica Bar Association or a General Legal Council or whatever, then that is a structured, or PSOJ or JCC, then that's structured, or a JITSA or Jamaica Computer Society. But we're suggesting that there are persons who may not be a part of any of those types of structures and or represented, and so wouldn't be represented by them per se. This is just for interpretation purposes now, if this can be read as widely as structured and unstructured, then we would necessarily have a problem and we would just leave it without the amendment. But if it is that in the interpretation of this, you're going to be looking at just structured types of trade associations and or organizations that represent groups of persons, then we would be minded to widen it a little bit to ensure that the commissioner has the power to speak to others that might even form a group informally and say, we want to talk to you. So that's essentially where we're going with the proposal.
For clarification, so it wouldn't mean a structured group, because body in its ordinary meaning would just mean a group, any group. So I'm wondering if you wanted to descend to an individual, or, well, if it's not going to an individual, then body would cover any unstructured group.
But is the issue so much that, or as whether they are really representing data controllers? Because to be a trade association, you have to be a body, whatever the nature of that body, representing data controllers. And there may be other persons who don't really represent data controllers, but have expertise or a strong view on the matter and want to have some input as to what the code should say. And I think that was the point, that they would want the minister to be able to consult with those persons if they so minded.
All right. So, Ms. Grant.
Just for clarification, you would be speaking about other than trade associations or bodies representing data controllers, other bodies who might not necessarily be trade associations or represent data controllers.
Yes. Yeah. Yes. I think we've landed. At a point. A couple of members indicated that they do have to leave at noon, so I'd love for us to go on to Part 2, Rights of Data Subject and Others. Clause 5 speaks to minors, the rights of minors, the rights of persons with physical or mental infirmity, and the spouse of those individuals. So, MSET?
So the concern here, members, was that there was appeared to be no reference to, or ability rather, for someone with a physical impairment to, via a power of attorney or some other authorization, method of authorizing some other person to act on their behalf. We simply moved into a situation where, in terms of Clause 5, where it outlines first the spouse and then it goes on to others, a child and so on. But nowhere in here does it say the stakeholders commensurately were. Nowhere does it say that the individual can, through a power of attorney, for example, or letter of authorization, empower someone else to act on his or her behalf.
They want to create some element of choice, that the person with the vulnerability can choose who they want to represent them. Well, as long as they're sufficient, they have the necessary capacity to make that choice, mental capacity, I mean, then I would say yes.
But this one is for
physical or mental.
The proposal is in relation to persons who are suffering from physical infirmities, not the mental, because the mental will go in accordance with the mental health act and the appointment there.
You have mental here, right? By reason of any physical or mental infirmity, is unable to act. It is saying the rights may be conferred on the spouse of that individual.
But what we're saying as we continue on to the other page, on page 32, is with respect to persons suffering from mental infirmities, the clause provides for categories of persons to act on behalf of the data subject, similar to the categories of the nearest relatives in the Mental Health Act. This is essentially the categories of person who can act for someone under that act. But we know that act, you have to go through a particular process to have that person
So from a drafting perspective,
appointed.
you're going to have to, because you have physical and mental in one chapeau there, so I guess you'd have to do something to deal with the physical, having this option available to them.
Well, I'm having a challenge with the proposal because I think what was being dealt with here is the exercise or the transfer of the rights, not really the concept of somebody acting on behalf of, which is agency. This was dealing with the transfer of the exercise of the rights in the case where there was some lack of capacity, either due to age or mental infirmity. To appoint an agent to act on your behalf when you don't have a mental capacity issue, then it's something different. And I'm not sure that the two should be merged together. Also, if that's the case, if there's a provision for persons with physical infirmities to be able to appoint an agent, that would also apply to any other case where a person might need to appoint an agent. For example, if a person is not in the country. So I don't think the two provisions should be confused. I also think that this whole question of agency is not specifically dealt with anywhere in the Act, except as concerns the issue of consent, where the bill does refer to a person being able to give consent by their legal personal representative. And then the various provisions in the standards also talk about the person being able to authorize who their information is disclosed to or who can supply information on their behalf. So I'm not sure that we need to really cover this issue separately.
I think we're, in terms of the comments that the committee received in relation to this, is that the bill seems to be limiting the choices available to an individual, and essentially is saying, if it is that someone is going to exercise your right under this piece of legislation, if you have a physical, let's leave the mental for now, if you have a physical infirmity, for example, that person must either be your spouse, a child, a parent, and I think what the argument could be is that if I wanted to choose my friend, I shouldn't be restricted. So I should be enabled to appoint whomever I want to appoint, not just these limited to carry out or to perform my rights or carry out my rights under the legislation. I think that's a concern.
So you're proposing an F then after E? Is that it?
I think before we get to how you put it in, Minister, just to clarify the issue, because isn't this really dealing with agency? Because it's saying who can exercise rights on behalf of the disabled person. I mean, in a sense, it's a limited form of agency.
No, I don't believe so. It's not agency because it's saying that the rights conferred by this part may be exercised by a parent or legal guardian. So there's really no requirement for the person to be acting on your direction. And in fact, if you're a person who has a mental infirmity, you might not be in a position to be giving direction. So it's not agency. It's really a transfer of the exercise of the rights.
In a sense, it's, well, I don't know if it's a transfer of the exercise of the rights, but I take your point that in some instances, the authorization of the person who would otherwise have to exercise that right doesn't depend on them doing anything. The statute is saying this person may exercise on behalf of that person. But in a way, because the whole concept is A acting for B, and it is akin to agency. So in a sense, it wouldn't be an aberration. Or let us not use that word since you don't like it. But it is like it wouldn't be an aberration to expand this list so that in relation to persons with physical disabilities, they may elect who they wish to exercise their rights on their behalf.
But except, remember though, I don't know, maybe I'm reading it incorrectly. I thought it was dealing with persons who are unable to act. So they're not even in that sphere where they can choose.
Physically disabled persons.
It says is unable to act.
Able to act, this provision wouldn't apply to you, and the normal rules of agency would then apply to you, because then you would just simply be directing somebody to act for you, and then the data controller would have to be looking to see whether the appropriate consent was given by you as the person who has the right under the various provisions of the Act. So I don't think we should confuse the two.
I wondered, if I may though, Minister, Mark, you finished with your line of question? Because I may raise a different issue.
I mean, when you say unable to act in the context of somebody with a physical infirmity, you know, as a practical matter, it may not be that they can't move at all or whatever, but it may be very challenging for them to exercise their rights. And it may be that they would be more comfortable, they may have trust and confidence in somebody else other than who we are imposing on them statutorily here. And I think that's why they have requested that they be given that ability to choose someone of their own choice, you know. Yeah.
What kind of physical infirmity did you contemplate that would prevent somebody from being able to act? Because that's the first point. And the second point is that based on practical experience, there are many, many persons who the last person they would want to do anything on their behalf is a family member.
With respect to the first question, we were just having the discussion, and I was explaining that in my reading the context of it, although perhaps it could be made clearer, being unable to act here must mean being unable to act in terms of being unable to exercise the right yourself, the rights conferred by this part.
That inability imports what, though? In other words, what would be the nature of that person's situation that would prevent them from being able to exercise their rights? You know, is it a practical matter? Does it mean they have to be able to operate, go to a location, or does it mean they have to be able to operate a phone? Do they have to have the financial resources to do it? I don't know, you know. But all I'm saying is that there are lots of different things that an inability to act could be caused by, you know. But the principle of allowing a disabled person to choose who they wish to exercise their rights rather than choosing it for them, I think is sound. So I don't know why we'd resist it. Yeah.
All right. I think we go for wider than narrow.
Yes.
Okay.
Chairman, I just have a question for the ministry's team. I noticed in the construction here, you have A, B, C, and you exclude accordingly. And I wondered what was the reason behind it, because it seems to me, you know, when I read it, what comes back to me is a table of distribution under the Interstate Estates and Property Charges Act, where if A is not present, then it can go to B, but you have to, of course, exclude the hierarchy. And I wondered, and I understand the reason for that, but in this purpose, I wondered what is the reason for that. I don't, and my suggestion now is, I don't believe that we should have it this way. You should have a list of persons who can act on behalf of the person who is unable. Yeah, instead of having a table of hierarchy, you just have a list of persons, and anybody on that list can act. Because the truth is that I may be unable to act, and my child may be there, but the last person I want to act for me is my child. Is it that if a child is present, then I cannot get my siblings to act for me? So I'm just throwing it out for the technical team, unless you have a very compelling reason for putting it in this hierarchical system. I propose that we just have a list of persons who can act, and then we say such other person as provided under power of attorney or the recommendation that the CPC is making. I think I like that as well. So the first question is the reason for the hierarchy, and the second, whether my proposal is something that you would consider.
So you're saying, colleague Binns, you're saying just the mere fact that it is listed suggests that you have to go first to the spouse and then to the it mandates.
Instead of having that kind of mandatory hierarchy, that you just list a group of persons who can act. And I tell you why I say that. You know, a real example I have is making an application under the Mental Health Act. And you know, under the Mental Health Act, it states the persons who can act. And I'm in a particular situation now where the closest person who can act in Jamaica for my client is somebody who does not want to act. And my client is in a position now, but we have to comply with what the Act says. And so, you know, using that experience, I think it may be best for us to just list persons who can act instead of putting it in that hierarchy.
I think
one of the suggestions made in one of the presentations was that a new F could be added to enable the court to have a power to appoint the appropriate person. That was one of the suggestions. So it wouldn't be left to just this list of individuals, and would cover a case where there really is no nearest relative able to act, or if there's a dispute as to which relative is the appropriate person to act.
But that would not, I mean, I take the point, and there's always that recourse to the court, but it still would not solve the issue. I have CPC, which is that based on the table, I'm going to call it table of distribution here, right? But based on the table of distribution, if I am unable to act and my child is present, then whether or not I want my child to act, my child can act. Yes?
Yes.
If I prefer my parent to act for me, as long as my child is present, that can't be, unless I go to the court. And then, you know, there's apparently there may be, and then there's an inherent jurisdiction the court may have. But the problem is that the court cannot vary this power here. Yeah. You're right. The court will not be able to vary the act. And so I think that for ease, just put or. Just take out if A is not present and just put or something like that. I mean, you're the drafts person, you're better able to.
Okay.
Chair, if I may.
MSET, AG.
Maurice Bailey, Legal Reform Department. Chair. It may be of some...
CPC. Legal Reform.
That's
okay.
Me, Chair. It may be of some, benefit to the committee to consider The Disabilities Act, Section 3, provides that the principal objectives of this act are to promote individual promote individual dignity and individual autonomy, including the freedom of choice and independence of a person with a disability. And I think this is certainly in the spirit of what is being discussed by the committee. It would seem to us that somebody who has a physical disability, unlike somebody with a mental impairment who have a difficulty making a choice, informed or otherwise, is in with a mental disability. I don't know.
All right, so you're pretty much supporting that person should have the right to, you're pretty much supporting that we should widen the rights and that we should not make it hierarchical, right? That it should be the or.
We would support that, Minister.
All right, excellent. So committee, we are agreeing?
Chair,
What?
we were suggesting another alternative, a much simpler approach.
Is it that if we're reading all of them, or just charge us 10C?
It would just be C.
Okay. Yeah, I can see the need for protection of a person with a mental disability by having a hierarchy like this, but for the physically disabled person, I think the choice should be entirely up to them. Yeah.
We're agreeing. Yeah.
Sorry, Minister, we were looking at the privacy regulations in Canada.
So go back first to the act.
So the enabling provision allows generally for the governor and council to make regulations which sets out persons who can act, whether you're a minor, a deceased person, etc. In the regulations, Regulation 10C allows for, there's a hierarchy, it's not, technically speaking, it's not a hierarchy, it sets out the group of people, but there's a general provision that allows for any individual that is authorized in writing to act on behalf of any of those classes of persons. So that's an option that could address some of the concerns raised by the members.
I don't really see how.
That
I don't
person
really,
would have to be
to be able to write or dictate that. No,
it's just in terms of a guidance, but subject to how we would want it to operate. I was just recommending the approach that was taken in Canada in terms of setting out who could. So you may have, for example, a relative, and Member Fraser-Bin said, she may not want her child to act, but you have an option of a person who is authorized. Whether we want it to just be some form of authorization, we could have that flexibility in it, but just to show the approach that Canada has taken.
Well, I thought we had agreed on that we widen the flexibility that the person with, physical disability has. We said that.
And the method of establishing that they have made that choice should be one which is appropriate to the condition that they have. So, to say they need to sign an affidavit if they have no arms or something, I think that the methodology of showing that they have granted that authority should be something that is reasonable or appropriate for the nature of their own disability. Yeah.
Sorry, Chairman, the reason I'd asked for us to do the intervention is it's actually a different approach, because here we have actually identified a list of persons. They didn't do that there. So that's what we're saying. That was an alternate approach. So here, no, you have to look at the different persons that have been identified here, unless it is, because I wasn't clear on when you're saying you're giving flexibility, is that you were giving flexibility in terms of the categories of persons as well as the manner? Because
flexibility means, if you look at page 31 in the ministry paper, the matrix, page 31, in the far right hand column, the ministry is proposing that provision be made for persons suffering from physical infirmities to be able to authorize another person to act on their behalf, either by way of a letter or authorization or a power of attorney. All right, so that's the widening of the rights that we're talking about. So that's one issue. The next issue has to do with what Member Binns raised, in that when you read what's here in clause 5A2, it suggests a pecking order, meaning you go first to that person's spouse. If they're not available or for whatever reason, then you go next to the child, then you go next to a parent, then you go next to this person, to that person, that person. That's what I thought she was describing as being hierarchical, rather than just setting it out as a group with the ability to pick from the group. Yeah.
Well, for that, in relation to the mental infirmity, I think the hierarchy may be appropriate, but I think there should be a provision that allows the court to modify that if on application. So, for example, in a situation where the person who would come first is somebody who another person has a strong reason for saying that person ought not to be the chosen person, the court would be able to vary that. Yeah, in relation to the persons with a mental incapacity.
What about the Mental Health Act? Does it already lay out the categories of persons who can? Yes.
On a different but related point, I'm going to ask if we are just given some time to look at the word infirmity. I know that the word infirmity is used coming from our constitution, but there have been concerns that it is insensitive, an insensitive term. It's not politically correct. So if you'll just allow us we will try to see if we can find some guidance, because it has come up in other committee meetings as well.
The question on the mental infirmity, whatever the correct word is going to be, is whether we should be prescribing that list here, or whether the Mental Health Act just applies to who can exercise the rights for those persons. And then for the physical disabled persons, we would just say, let them decide who they want to act on their behalf, and let them exercise that authority in a way which is appropriate to them.
I fully support the position of Member Golden, save and except that under the Mental Health Act, it speaks to the person resident in Jamaica. So yes, I wouldn't want us to adopt that part of it. Yes.
Challenges at times as to the appropriateness of,
Yeah. So how would somebody outside Jamaica act on their behalf?
All right, so members, I believe that for clause 5A2, there are 3 things to be done, but I think we are agreeing that for persons with physical or mental infirmity, the rights should be widened to allow them to choose power of attorney. Yes. Just physical, with physical infirmity, for the rights to be widened to allow them to choose power of attorney or authorize other persons by way of letter to act on their behalf. That's one issue. With the other issue has to do with just dealing with the hierarchy that's here, to eliminate the hierarchy. And then the third request was to look at the Mental Health Act to see if it prescribes how the rights of a mentally impaired person should be, right? Those 3 that I captured, committee? The 3, yeah.
Chair, I just wanted to throw for consideration whether that category, speaking about persons with physical infirmities, needed to be limited just to that, because there might be other cases where persons might want to appoint somebody else to exercise the right. So maybe it need not be limited to just persons with physical infirmities if we're talking about appointing an agent to act on your behalf.
Comments, MSET?
Chair, we would support that because it's wider than infirmities. The fact is you could be out of the country, but you still need somebody physically here to do something, exercise your rights on your behalf. And if you want to do that by letter of authorization or power of attorney, you should be allowed to.
All right, just to recap, I think we're agreed as a committee that this clause should be amended to, 1, widen the rights of persons with physical disability or other persons who are not even physically impaired in terms of the rights, allowing them to be able to have power of attorney, write a letter to say somebody else is acting on their behalf. In terms of persons with mental disability, to just do a double check of the Mental Health Act to see how it prescribes rights for persons with mental disability, and then to just change how A to E is listed so that it doesn't confer a pecking order, if you will, in terms of the persons who can act on the behalf of other persons or persons with physical disability.
I thought the point was made that in relation to the pecking order there, it might have been necessary based on the fact that the category there is persons who were unable to make that choice or decision, in which case there would need to be a pecking order because there would be but that person wouldn't be able to choose. And then the point was made that perhaps in that case you would resort to the court being able to modify the pecking order if need be.
Member Golden was saying, I'm the one that raised the issue of the pecking order, but then I took the point that Member Golden made in terms of separating the physical from the mental. And I think we have agreed how to treat with the physical, but in terms of the mental, I think what Member Golden was saying is that because it says that the person is willing or able to act, but there may be concerns about the suitability of that person, whether that person has the interests of the mentally incapacitated person at heart. And it is in that regard he made a recommendation that there should be recourse to the court to vary this order. And I think we are agreed on that, and we just close off by saying let us also look at how the Mental Health Act treats with the persons who can apply for guardianship under the Act.
In relation to mental issues, the existing hierarchy here will be maintained, but it's to add the provision for the court. With the mental
hierarchy
okay.
With what exists in the Mental Health Act, because we don't want to stray too far.
Right.
All right, so there's some work that needs to be done, some research that needs to be done to come back with this particular clause for our next meeting. And I think it's a good point to honor the commitment of those who have to leave at noon. But let me just say, in terms of dates of next meetings, as you are quite well aware, the parliamentary schedule is jam-packed. So we will meet next in September, Wednesday the 4th at 2 p.m. And I've taken the opportunity to schedule meetings for the rest of September, but we will go, the one after the 4th would be Thursday the 12th at 10, Thursday the 19th at 10, and Wednesday the 25th at 2 p.m. So that will be Wednesday, September 4th at 2 p.m., Thursday, September 12th at 10 a.m., Thursday, September 19th at 10 a.m., and Wednesday, September 25th at 2 p.m. Any other business? If not, this meeting is adjourned. Enjoy the holidays. Yes. Happy Independence, Jamaica. Yes.
Sorry, Minister.
The single best thing you can do to protect yourself when online shopping is to be careful about who you're giving your payment details to. If you're not entirely sure whether the retailer you're visiting is reliable, do some research to verify its authenticity and its security. Educate yourself.
Brutality isn't a legality. There's no rationality as to why this abnormality should become a mentality. A mentality which kills and tortures. Are you really telling me you're afraid to speak up because you might be called an informer? Let us break the barrier of brutality and enforce it with alacrity. If you know someone who has been victimized, I charge you to I, interrupt their situations before their O. Oppressor continues to L, lurk in their lives. Let us E, extend our hands to our brothers and sisters who are being victimized, and N, never see violent acts and ignore them. Let us C, come together and be the E, example, so we may end a barrier on brutality.
The corrupt are getting away too often. Help catch them now. Jamaicans must call